any event, 1101A states the general rule. And the general rule is that you may not introduce evidence of the 2007 theft in order to prove that Diane has a bad character, a character for being a thief, and that therefore the jury can assume or infer that she committed the conduct, that is theft, alleged in the current civil or criminal case. Now what's interesting about 1101A is that it is it's by the way on page 1 of the syllabus. It's a fairly lengthy single sentence, almost Faulknerian in its structure. One of the interesting things about it is the general rule is articulated in line 4 and 5 of that single sentence, and the sentence itself starts off with the word except as provided. So in other words, it starts out by listing the exceptions. And I don't know about you, but I'm the kind of guy who thinks if you start the sentence articulating the general rule with a list of the exceptions, maybe the exceptions are more important than the rule. And that is true here. If you look, you see that the exceptions are except as provided in this section, meaning other subdivisions, B and C, and in sections 1102, 1103, 1108, and 1109, the general rule applies. You can't introduce Diane's 2007 theft. We're not going to talk today about 1102, 3, 8, 9, in part because I used up so much time trying to tell a couple of jokes at the beginning. There's no time to talk about it, but also because really those are fairly complicated sections. They're strictly applicable in criminal cases, not civil cases, and that would deserve their own lecture, which I, by the way, would be happy to provide if the same salmon is served at night. 1101C, which is one of the exceptions, and that we're not going to focus on today, talks about a different situation when you try to introduce are those chocolate chip cookies? Wow. As long as salmon and chocolate chip cookies, and I'm here at night. Yes, at least one. Thank you. I told you you were smart. 1101C makes the point that the general rule of 1101A doesn't apply when you're trying to prove credibility as opposed to conduct. Trying to prove that somebody's not a credible witness. Of course, it doesn't tell us where to find the rules on that, but the rules on credibility generally are in sections 780 through 790 of the evidence code. And then we get to 1101B, which is the primary exception to that general rule, and that applies in both civil and criminal cases. And what 1101B tells us is that nothing prevents, 1101A does not prevent the admission of specific acts of misconduct that are not introduced to prove character, that are introduced to prove something other than character. And there's a whole laundry list of examples given in 1101B that I'm not going to recite to you, but I will point out, and we will focus on, the three most important types of facts that you might be proving with 1101B evidence that are not evidence of character or disposition, but are admissible evidence under 1101B. One of the things that I would like you to note in 1101B is that in describing the admissible evidence, it talks about evidence that a person committed a crime, civil wrong, or other act. So in our hypothetical, the happy fact that Diane was never prosecuted, much less convicted, in 2007, sad to say, is not itself going to immunize her, and now you, her lawyer, against the admissibility of the 2007 evidence, because it is another act. Second of all, there is no distinction between what we call prior and subsequent acts. The 2007 act is prior to the 2013 accusation, but it could actually be subsequent to when that happened, and the rules of admissibility would be the same. When we think about how 1101B works, think of the three most common defenses that somebody in Diane's position is likely to have. I'm not suggesting that when I was a public defender, I would sit down with my client and say, well, sir, you're charged with murder. So what are the possibilities here? One, you did it. Let's put that aside. Two, it wasn't you. Somebody else committed this murder. Identity. It's a whodunit. Or intent. Intent. It was you who done it, but you didn't mean it. Maybe you were drunk. Maybe you were afraid. Maybe, help me on this, I might say, you weren't filled with malice toward the victim, so-called victim. And the third, unlikely to occur in a murder case, but certainly could occur in the Diane's case, is that the act itself didn't happen. So, for example, Diane could say, hey, it wasn't me. I think the boss stole the money and he's blaming me. Or two, Diane could say, well, yes, I took the money, but I thought I had permission to take the money. Now, creating the dummy corporations may stand in the way of making anyone believe that, but possible. Or three, Diane might say, hey, you know what? No money was ever taken. The boss is making this up entirely. No act ever occurred. And actually what happened is he sexually harassed me, and when I confronted him on it, then he made up his role. So those are the three. Who done it? No intent. What was the state of mind? And the act didn't occur. Those are the three common defenses that might come up in a civil or criminal case of this nature. And here's how the 2007 theft allegation will come on. I'm sorry if I appear distracted, but I'm just watching people eating chocolate chip cookies all over the room, and not a single one of them is me. First, how do we distinguish when the plaintiff company wants to introduce the 2007 theft, and you, at this point, regretting that you went back to the office back in January of 2014 and met Diane? You want to keep it out. What you want to do is say, hey, this is coming in only to prove Diane has a bad character. This isn't coming in to prove identity or intent, or what we call plan and scheme. That is what we call the evidence when we're saying it proves the act really happened. It's coming in to prove she's got a bad character. Well, if you're the poor judge, how do you distinguish between this 2007 coming in for character or coming in to prove identity, intent, plan, and scheme? And the metric that we use is similarity. And it has to have a certain amount of similarity in order to come in for each of those purposes. And if it lacks that, I should say each, at least one of those purposes. And if it lacks that, then it's dismissed as, oh, coming in merely to show character or disposition. So the first example is identity. You might introduce it to prove identity. By the way, many of the cases listed in your syllabus are criminal cases. And I appreciate there's one or two criminal lawyers here. By criminal lawyers, I mean people who represent or prosecute persons. Otherwise, probably the number's higher than one or two, but that's not my opinion. By the way, I was so sorry to see that Kai left, because, and you're going to find this hard to believe, but yesterday during oral argument, one of the lawyers was channeling Kai during this argument, and it was amazing. It was fantastic. In any event, Diane says, hey, it wasn't me, it was the boss. So now they're going to say, okay, we want to introduce this to prove Diane was the one who stole this money. In order to do that, and I refer you to two cases, Rogers and Scott, which are cases number 1 and number 2 in the syllabus. Rogers and Scott, both of which are criminal, set out the rule. Now it's interesting, there are no cases, published cases that I'm aware of, where identity has come up in a civil case, published case that involved a civil litigation. But I have no reason to believe the rule would be any different, and it could come up just as I described it in the Diane hypothetical. The test is similarity, and with identity, it has to be the highest level of similarity, greatest similarity, in order to introduce the evidence to show identity. Back when I was practicing law, the cases seem to describe that in a way that's a little bit different than the Supreme Court is describing it now. And not surprisingly, for the cluster of criminal defense lawyers over in that part of the room, the current Supreme Court defines the test on identity as a little bit looser than it used to be. We used to say that the similarity had to be like a fingerprint, unique similarity. Now what they tell us that is that it does not need to be unique. It needs to be very, very similar, but not unique. And to quote them, it says, the inference of identity need not depend on one or more unique or nearly unique common features. Features of substantial but lesser distinctiveness may yield a distinctive combination when considered together. And they no longer say it has to be like a fingerprint, they say it has to be like a signature, which means it has to be pretty similar, but not unique. So, if, for example, I told you what the 2013 theft involved, these dummy corporations. Supposing the 2007 incident involved an accusation that she had every once in a while, 3 or 4 times a day, dipped into petty cash. Probably not that frequently, but she had dipped into petty cash and taken a 20 or 100 or whatever she could get her hands on. That's not anywhere near similar enough so that for purposes of identity, you could introduce it. The next area, which I think is the most interesting area, because it is an area of rapid growth in civil cases, is the area of state of mind or intent. And most of the civil cases, by the way, deal with the employment context. Intent requires the lowest level of similarity. So if our case involved Diane saying, yeah, it was me, but I thought I had permission to take the money, and so I didn't intend to steal it, so the company has no right to sue me. Certainly I couldn't be prosecuted for it. Then there would be a much greater likelihood. Tell her she likes the raisin oatmeal. She's a raisin oatmeal. Yeah, there you go. I'm afraid she'd start crying now. Anyway, the level of similarity is so low that's required by the cases is so low that there would be a very good chance that the 2007 case would come in to prove, if intent is an issue, to prove that in the current case. Certainly a good argument for you as Diane's lawyer to craft some defense other than one that puts state of mind at issue. But let's move on to the civil cases, and these are all on the list as well. That, as I say, relate to the employment area. The first, and in some ways, I think most important case to be familiar with is Pantoja versus Anton. I say most important not because it is a sexual harassment case against a lawyer, but because the judge who wrote this, justice who wrote this, Becky Wiseman, who actually lives in Contra Costa, is quite expert in employment discrimination law. And she wrote a very expansive opinion and discussed numerous one California and numerous federal cases in this area when reversing the trial court's exclusion of what is called in the civil area, but interestingly enough, not in the criminal area, although it's the same kind of evidence, Me Too evidence. And in Pantoja, the woman who claimed that she had been sexually harassed and fired because of her unwillingness to put up with it, she had, the boss was saying, this is ridiculous, I've got a very firm rule against doing anything like this, and I didn't touch anybody's body parts where they weren't supposed to be touched. Well, she had 3 or 4 other women employees from the company who were prepared to say, he used language that was terrible to us, he touched us in places he shouldn't touch us. And the trial court excluded it. And the Court of Appeal reversed and sent it back and said that this Me Too evidence is absolutely admissible. Intent is clearly a part of employment discrimination in sexual harassment law. And that intent was clearly at issue in the case. And particularly on the wrongful termination charge, where the intent is almost always what's key. Pantoja relied on a case called Johnson versus United Cerebral Palsy. Pantoja, by the way, is the 6th case on the syllabus, and Johnson is the 5th. Johnson was a pregnancy discrimination case, and Johnson had several women who had been fired soon after informing the employer that they were pregnant. And again, the trial court excluded it, and the Court of Appeal reversed. The level of similarity was clearly not would not arise, in my opinion, to the level necessary to prove identity, but was clearly enough to match the much lower standard of similarity required to prove intent. And motive, another state of mind, often relevant in those kinds of cases. McCoy, a very recent case, number 7 on your list, and you'll notice each of these cases are cases that have been decided in the last few years. So they're all recent cases. McCoy expanded this beyond employment, wrongful termination and sexual harassment to retaliation, and found that the trial court made a mistake by excluding evidence. Here's what happened in McCoy. A woman filed, along with several other women, a lawsuit against the company saying that she had been discriminated against because of her gender. She won. Part of the relief was that she was to receive training so that she could get a higher paying job in the company. And she basically, her position in her lawsuit was they never followed through on that. The men who were in charge of training her wouldn't even talk to her, made comments about her behind her back. And she had other women who had been part of the lawsuit given the same relief and then suffered the same consequences. So that when the retaliation occurs as a result of the same actions, protected actions, by the plaintiff, McCoy says that even in a retaliation case, because intent is important, is a critical element, it will be admissible. The Hatay case, which unfortunately I didn't write the number down, but I'm going to guess it's number 8. Hatay actually cut back a little bit on this, but it's useful to know this, and that is in Hatay, the plaintiff alleged that he was Asian, Japanese actually, and that Mr. Hatay, his supervisor, had discriminated against him, and that based on his Asian/Japanese heritage, ethnic background, he had been a victim of discrimination. As the case develops, the plaintiff learns about other people who were discriminated against, who, sad to say for the plaintiff, were not Asian or Japanese. And so he then seeks, without amending his complaint, to reformulate what the problem is so he can get these people to testify. And what he says the problem is that Hatay was Arabic, was an Arab, and he discriminated against everybody who wasn't an Arab. So actually the class of victims is far broader, so my Me Too evidence can go to someone who's not Japanese, not even Asian, but was discriminated against by them. And this was a case of discrimination against all non-Arabs, and the trial court and the Court of Appeals said, no. You pled this discrimination. You can prove Me Too evidence when it relates to that discrimination, but not some other form of discrimination. So that is intent. How you can prove intent and avoid the argument that you're only introducing evidence to prove disposition. Finally, common planner scheme, where you are trying to show that the act actually occurred, because Diane said no, there was never any theft. The criminal cases of Ewald and Balcom, numbers 15 and 16, actually reformulated the whole law of common plan and scheme evidence in criminal cases. The Brown case, which is case number 11, followed Ewald and Balcom and talked about a case where somebody was, a landlord was accused by a tenant of a Fair Housing Act discrimination because she refused to go along with his sexual harassment. He said, yeah, I'm the landlord. There's no identity problem. And there's no dispute that if I did what she says, that would be sexual harassment. But that never happened. It's all a lie. And so it was the act in Brown, just like in Ewald and Balcom, that needed to be proved, just like would exist with Diane if Diane's defense is as described before. Common plan and scheme, the amount, the level of similarity is midway between identity and intent. It need not be unusual or distinctive, the two incidents, but there must be, this is actually a great large number of words that's a little hard to figure out what they mean by it by the Supreme Court, a concurrence, such a concurrence of common features that the best explanation is a general plan of which they are individual manifestations. They can't simply be similar but spontaneous acts. So that describes admissibility under 1101B, evidence that can come in despite the general rule in 1101A. And Section 352, of course, as with all otherwise admissible evidence, applies. And a great case for looking as to how 352 can exclude admissible evidence under 1101B is the Lopez case, which is a criminal case, but would apply certainly in civil cases. That's the number 3 case on your list. And I can now step away from my outline because I have nothing in my outline on ethics, and bring in the ethics portion. You have the first item on your syllabus is Rule 5200 of the State Bar Rules, an area of the annotated code that I had not found myself lost in for many years. And it tells us the unsurprising thing, for most of us unsurprising, that in appearing in front of a tribunal, you may not lie about the facts or the law. It's not saying you can't be wrong, but you may not lie. And one of the purposes of my discussing 1101 is that it's a fairly intricate area, and after you claim this as for MCLE credit, it will be a lot harder for you to defend an ethics action on the basis that you made a mistake and really didn't understand the law. On the other hand, you can then point out that while Simons did an amazing job discussing it, we didn't have any wine beforehand, and we were really not able to understand it as clearly as we might otherwise. But I want to go beyond 5200 into what I think is fair to say is ethically related issues. And that is the notion of being a lawyer who prefers to ask forgiveness instead of permission. This evidence, 1101B evidence, is very powerful evidence to have in your briefcase. And any lawyer will want to get that evidence out of their briefcase and in front of the jury. And it is very tempting to do that without going to the court and saying, Judge, I have this evidence and I would like to have a ruling. And you might think, well, supposing there's been discovery. I mean, I'm the plaintiff, put aside discovery. Diane certainly knows about this. Let her raise the objection. If she doesn't raise the objection, it so happens that Diane has forgotten that she mentioned this to her current, up until recently, current boss at some point, that she'd had this little run-in, and she hasn't mentioned that to you. And sure enough, the lawyer from the other side hasn't bothered to point out that he's going to ask the boss that question. And during the course of the boss's testimony, he asks the boss, anything else that led you to believe Diane might have been the person responsible for stealing it? And boom, in it comes. Yes, Diane told me that she had this 2007 incident. And everybody gets unhappy, and you, who chose not to ask permission, but to ask forgiveness, now do that. Let me point out, is that an action that's apt to wind you up in front of a state bar? I wouldn't think so. But what do judges do when judges get together and have lunch, or get together and have coffee in the morning, or get together at the Bar Association lunch? Well, they discuss erudite topics of law and governance, but they also gossip. And one of the things they gossip about is the lawyers who are appearing in front of them and what nefarious deeds they do. And because I want to leave a fraction of a minute for questions, let me just say, you don't want to be that lawyer. You don't want to be the lawyer who they say, watch him or watch her, because she will try to sneak in anything she can and apologize profusely if you say it shouldn't come in, and hope that you're not going to declare a mistrial, which judges are loath to do. So, in any event, I will leave you with a thought that kind of gets back to one of the themes I've had today. As we approach the drought this summer, I'm reminded of a slogan that was current back in the time when David and I were a lot younger, and that is, save water, drink scotch. Do I have a minute? Man, I don't want to keep anybody here. Anybody have any questions? None? No, I'm sorry. Anybody have any questions? I thought my daughter was going to raise her hand and ask me. Okay, great. Thank you very much.